So the federal law which prohibits nonviolent felons from possessing firearms has once again been ruled unconstitutional after the Supreme Court's recent 8-1 decision and GVR of the case. And now the AG's office has decided to not contest that Pro 2A ruling, and they decided to not contest it in front of the Supreme Court. Instead, they're going to let this stand. So this is a huge development that we need to talk about. Now, before we jump into this video, I want to thank the sponsor of this video, which is TacPack. TacPack is a subscription-based box that delivers tactical and EDC gear to your front door every single month. Every month, TacPack offers 2 different tiers. You can either get the standard tier or the plus box. Personally, my favorite is the plus box. And right now, TacPack is doing something special for my viewers. If you use the code ARMED and it's your first time ordering and signing up, you will receive a free $60 tactical gear box along with your subscription. So I will leave a link down below to TacPack where you can sign up. It's pinned in the comment section as well. And if it's your first time and you're signing up for the first time, use that code ARMED to get that free additional tactical gear box worth $60 or more. Now, as I mentioned in the intro, in this video, we're going to be talking about a critical Second Amendment case involving nonviolent felons and their ability to possess and own firearms. The Trump administration and the AG's office have now decided to let the Range versus Garland case and let that ruling, which was issued by the Third Circuit en banc panel, they are now going to let that stand. They are not going to proceed forward at the Supreme Court level. That means that the Third Circuit ruling, which found that the federal nonviolent felon possession law will in fact stand now as unconstitutional, and it's going to be unconstitutional as applied to Mr. Range. Now, this is a huge win and will now allow more individuals to do the same thing that Mr. Range did to get their gun rights back, to go through the process if they need to actually sue the federal government and get those rights back. You also recently had the administration issue the proposed rule change, which would allow for the gun rights restoration of prohibited individuals for the first time since 1992. The Range case and them not proceeding forward at the Supreme Court level, along with this new rule change, is going to change the Second Amendment landscape when it comes to the restoration of rights. Now, for those not aware, the Range case involves an issue of an individual losing his 2A rights under the federal laws essentially forever. 26 years ago, Mr. Brian Range was convicted of concealing some of his income so that he could obtain additional food stamps for him and his family. Essentially, he simply made a false statement on a federal form to get food stamps, and because of that, he was convicted of a Class 1 misdemeanor, but since it was a year-plus time potential in jail, according to some of the settlement stuff, essentially, he is now barred forever from being able to own or possess firearms, and because of that, he had sued the federal government for the restoration of his rights. This eventually made its way to the Third Circuit for the first time, and on review, the 3-judge panel in the Third Circuit issued an opinion citing history and tradition in finding that individuals constitutionally entitled to bear arms are only law-abiding responsible citizens. In essence, they ruled that Mr. Range is not one of the people afforded protections under the Second Amendment. This case then went to the en banc panel for the first time in the Third Circuit, and essentially they held that 922G1 as applied to Mr. Range is in fact unconstitutional. The Biden administration at that time then sought Supreme Court reversal of that decision, but after the Rahimi 8-1 decision, the Range case was then granted, vacated, and remanded back down to the Third Circuit en banc panel for a new decision in light of Rahimi. But on re-review, the Third Circuit en banc panel ruled in the same way. In that decision, they stated that we agree with Range that despite his false statement conviction, he remains among the people protected by the Second Amendment. And because the government did not carry its burden of showing that the principles underlying our nation's history and tradition of firearms regulation support disarming Range, we will reverse and remand. They stated in the opinion that at the root, the government's claim that felons are not among the people protected by the Second Amendment devolves authority to legislators to decide whom to exclude from the people. We reject the approach because such extreme deference gives legislators unreviewable power to manipulate the Second Amendment by choosing a label. And that deference would contravene Heller's reasoning that the enshrinement of the constitutional rights necessarily takes certain policy choices off the table. In sum, we reject the government's contention that felons are not among the people protected by the Second Amendment. That decision by the Third Circuit en banc panel was issued in December. Like I mentioned, the federal government at that time, the Biden administration took this up to Supreme Court. And once there was the administration change, Pam Bondi had this in her control and she had to decide what she wanted to do with this case. Recently, they asked for the extension and that extension went out until April 22nd. So they would need to decide if they wanted to proceed forward with this case in front of the Supreme Court by April 22nd. And like I mentioned, that timeline has now come and gone. April 22nd went without them filing a petition. What that likely means is that the office, maybe through the new advice of the new 2A task force, decided to just give up on this case, wash their hands of it, and not proceed forward or file Supreme Court cert. I also suspect that the recent DOJ interim final rule on the restoration of rights had a lot to do with this decision to essentially abandon the range case and let that sit as precedent in the Third Circuit. The recent DOJ rule removed the Attorney General's delegation of authority to the ATF to process applications for the restoration of rights under federal law. The DOJ stated in the rule notice that the rule removed outdated regulations and it is part of the broader review of firearms-related policies under Trump's executive order to protect Second Amendment rights. Through the interim rule, the DOJ will begin to allow individuals who are not dangerous to public safety to use the statute and petition to have their gun rights restored. Since 1992, Congress has prohibited ATF from using funds to process gun rights restoration applications, making the statute essentially obsolete and useless. This interim rule changes that. It now will allow for an avenue to restore rights at the federal level. Under the interim rule, the ATF will no longer handle relief applications. DOJ will instead carry out the statute and process petitions for gun rights restoration. And one of the important things is that this DOJ rule went into effect essentially immediately. There's going to be some public comments and things like that for a final version, but this has already gone into effect, and we're already seeing some people go through the application process. What all of this means together is that there has now been a very significant shift within the AG's office and the DOJ when it comes to nonviolent felons, this issue of them being able to purchase, possess, and use firearms. They appear to have abandoned the range case, letting the Third Circuit en banc panel decision sit as precedent, and the new rule on the restoration of rights will give another avenue for people to obtain their rights once again. Now, when it comes to the range case, like I mentioned, that is an as-applied challenge, so this specifically right now only applies to Mr. Range, but that sits as precedent in the Third Circuit, allowing more individuals within that jurisdiction to now challenge if they want to through the lawsuit process and have that range case sit as precedent. And then also you're going to have other jurisdictions, which we've already seen some cases citing to the range case as, persuasive in allowing that to proceed forward in their jurisdictions, especially now knowing that the DOJ is not going to contest that. It would be a good opportunity now for other jurisdictions, if they want to now bring those challenges, those as-applied challenges for the restoration of rights. But you also have this another avenue through the DOJ process, through the AG's office for the restoration of rights that they just opened with the new rule. So this is all great news coming out of the administration, and it appears that the 2A task force is working quickly to correct a lot of these outstanding lawsuits and issues. We'll now see what happens going forward, and if anything strange develops, maybe if something behind the scene where they got an extension of time and they are going to file the petition. I don't think that that's what's happened. We didn't see anything hit the docket either yesterday or today yet, but if anything changes, if anything develops, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.